Good afternoon and welcome to today's presentation, Using Medical Legal Support to Optimize Your Case Outcomes. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes and should not be used in a court of law sans the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Ms. Katz will discuss medical file reviews, chronologies, expert witness, cost projections and life care plans, case management, vocational rehabilitation, IME, peer reviews, elder care management, and guardianship support. To give you a little background about our presenter, Deborah Weiner Katz is the president and CEO of Advanced Rehabilitation Management Incorporated, which she established in 1990. Debbi is a graduate of Temple University's occupational therapy program and has worked in rehabilitation for 35 years. Her background is extensive and includes work in pediatrics, psychiatry, developmental disabilities, physical disabilities, geriatric care, and catastrophic injuries. She also has established and operated a multi-disciplinary outpatient brain injury treatment program which serves individuals following an acute inpatient stay in a rehabilitation facility. The program has supported individuals of various CLAs and focused on community rehabilitation and integration. In addition to working as a clinician and program administrator, she has worked in almost every aspect of care management, litigation, support, and cost evaluation since 1983. Attendees who require passcode, the word for today is support. During the Q&A session, we ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will send out an email with a link to the archived recording of the webinar. The slides can be downloaded from the resource list at the widget at the bottom of your screen. Thank you all for attending today, and Debbi, the presentation is now turned over to you.
Thank you, Rochelle, and thank you everybody for attending. I can't see everybody, so that makes it a little bit hard to ask for a show of hands of what your practices are. But when we get to the Q&A portion of this, if you have questions unique to your practice and experience, please feel free to ask. So today I want to talk about using medical legal support to help improve the outcomes on your cases. And that little slide is of me. And I want to talk about what medical legal support is. So I think the best way to explain it, the terminology is my terminology, medical legal support. I think the best way to explain why I call it that is that most of the people on the phone here are attorneys. Most of you have experience in the law and have handled cases where medical issues involved. Someone who is a medical legal support expert comes from a medical background and has been exposed to the legal side of things, but really has more of a command of the medical side of things. And when you've lived in that world and have dealt with the legal side of things, you bring a new perspective to the cases, which may actually be a significant benefit to the attorneys handling the files. So I'm going to talk a little bit about what I call the tools of achieving good outcomes on cases. And I guess I do want to take a second to dispel the myth that working with a medical legal support expert is always going to cost you a fortune, because it won't. What the expert does on the file is really dependent on your conversation with that expert and what you and they agree to work on. So I'm going to go through some of the, quote, tools that we use, and it may give you some different ideas on how to approach your cases, but I would strongly recommend that when you contact an expert that not only do you have maybe an idea of what you are looking for, but also what you want to accomplish, what your budget is, so that I think a good combination of skills, and you get a better outcome on your case. So I'm going to go through some of the tools that I use, and I'm going to try and give some case examples, and hopefully that will spark some ideas and questions on your end. I believe that many of you have heard of a medical file review. It sounds pretty straightforward, but I think we can talk a little bit more about how to use the medical file review. Basically a way to kind of look at big picture, from big picture down, where you are on your case, what the medical issues are, and what the long-term issues might be on that case. A medical file review can look at, I said, a comprehensive review of the cases. Oftentimes we're consulted to look at pre-existing issues and maybe where are there problems with the case. In addition to getting a good outcome, a good expert will also help you to find out what the barriers are to success so that we can help to figure out how to overcome those barriers to success. And while a pre-existing issue may sound ominous, oftentimes there are ways to get around that. You just have to know it exists so that you can develop a strategy to get around that issue. A medical support person can also help figure out what questions you want to ask of your other experts, or figure out which experts to use on your files. Maybe additional recommendations. The medical person who's doing the review of your file will help to identify some evaluations for treatment. So, example, I frequently see indicators of a brain injury that were never worked up because perhaps the ER minimized it or the primary care physician didn't work it up, and we may be able to recommend a different path for treatment so that you develop that case and get documentation of problems that are the result of a particular incident that you're going to be able to use in your case or look at in your case. Functional problems and future care needs. I mean, when you look at a case and developing what the case is worth, understanding what's wrong with the person is important to understanding or to establishing that worth. So looking at what problems will result from particular medical issues will help to establish that vision of what the future problems might be. Identifying resources to make sure that the client gets good care is important, and we're going to talk about that more later, and looking at the long-term impact of the injury or disability. So here's an example, and I do like to use examples to drive my points home, so you're going to see that I talk about some tools and then how we were able to use that tool in a real-life situation. So this example is of a woman who was involved in a motor vehicle accident. She actually had pre-existing wrist injuries. She was referred for surgical intervention and declined. She had a lot of pain, and she worked as a florist prior to this accident, but she couldn't afford to take time off from work, and she was able to, for lack of a better word, push through the pain and do her job and manage every day and take some medication and live life without surgery. So she gets into this accident where, and this is very typical in an accident, wrist injuries, because you tense up and the wrists get jammed and you experience either carpal tunnel or wrist injuries, and she did further damage to that wrist. And so when she went to go back to work, she couldn't do it. She was just in too much pain and she couldn't push through it. we were consulted, we did the file review, and were able to establish some very specific strategies for trying to demonstrate that her pain was worse and how to go about talking to the orthopedic surgeon to get him to document it. We were able to make a case with the functional information that we gathered from the chart, where the orthopedic surgeon documented that there were new injuries. The other side didn't want to even acknowledge that there was a new injury with this accident and laughed because she was recommended for surgery prior to the accident. But they were able to settle the case and make the case that she actually sustained significant changes in her ability to do things on a day-to-day basis, and they were able to get a settlement on that case. So that was an example of where a medical legal support person was able to provide some guidance through a file review to come out with a better outcome. Chronology is something you probably all have heard of. On the surface, it seems pretty simplistic. You're taking the medical records, putting them into making a synopsis of them and putting them into sequential order, developing a timeline. Some firms will use their paralegals to do this, or a secretarial staff person who's familiar with medical terminology to do this. I would submit that in a complicated case, it may make sense to use somebody with medical background, a nurse, somebody who's used to looking at medical issues all of the time. We just did one where there were 1,500 pages, I think, and there were 6 accidents. And we were able to create a timeline with identifying the MRIs and identifying the injuries with each accident and the subsequent changes in functional status, so that the attorney involved was able to prepare a defense and move the case forward with good, solid chronological information to see how the different points in time impacted the client's function and where they wanted to focus their efforts and develop a good outcome. I would also submit to you that it is an option for you to be able to speak with the person before they do the chronology, because it can be customized. So I have about 10 different formats that I use for chronologies, and depending on what your goal is and what you're trying to look at, we can narrow down the focus to a certain point in time, to certain information like studies, to certain providers, to being able to sort by page. So I call it garbage in, garbage out, but when you're working with an expert, you really want to tell the expert what you want so that you can get the best outcome and the best bang for your buck from that particular endeavor with that expert. So it looks like when I slip to the next slide that we have a Q&A stop. So does anybody have any questions so far?
If all the attendees can enter in the passcode and any questions you have. I don't see any questions so far, so if you just want to continue with the presentation, that should be fine.
Okay, and if at some point you see a list of questions accumulating, just feel free to interrupt and I'll stop. No problem. So we'll move along and we'll go from the more simple kinds of tools to, maybe some of the more complex tools. I know most of you work with TASA for expert witnesses, and the typical inquiry that we see when somebody's looking for an expert witness would be a malpractice case or, a situation where you're looking for specialty to specialty kind of expertise. So somebody fell off the recovery table and were the standards of care followed so that that could have been prevented. Does this case have merit? Does this case have, Was there a problem with the documentation that can be zeroed in on? And with peer-to-peer expertise, the expert is able to not only develop that information for you, but also be able to testify, document and testify on that information. Obviously, sometimes that information does not include a report because it's perhaps not beneficial to your case. And anytime you retain an expert witness, to do reviews, I would strongly advocate to get the verbal before you get a written report, because if it's not useful, it doesn't have to be documented. But I would say, that there's a wide variety of experts that you can use for your cases, and, don't be shy about asking for specific specialties. Okay, I'm going to go into life care plans and cost projections, which I think is something that most legal experts or legal attorneys who deal with expert witnesses have at least heard of life care plans and cost projections. They're two different, they're similar products with two different purposes. So a life care plan is that long and drawn out 30, 40, 50-page document. And I would say that a life care plan is a wonderful document if you're planning to take it to trial. That plan is long because it's typically developed so that the expert who you retain is able to testify on that report. The data that's in there is researched very carefully and defensible using standards of practice that are accepted within the life care planning community. It tends to be a costly tool, and it may not be where you need to go as a first step when you're looking at settling a case. So you might want to know the same information. What is my case worth? What kinds of things is my client going to need at the end of the day, so that I have a basis for asking for a certain demand, but it's not necessarily being prepared to go to court. And in that case, a cost projection can be used, kind of an abbreviated version of the life care plan that wouldn't be as long, wouldn't be as costly to do, and may give you some good information to settle the case. I would caution you on one thing related to the cost projections when you choose a cost projection versus a life care plan. Because the cost projection is not developed to be used in trial, you don't necessarily want to put that in the hands of the other side so that they could then later summon the person who did the cost projection to come in and testify on it in a trial. I will always document in my cost projections that it's not prepared for trial and that it's preliminary tool to be used for discussion and settlement purposes, but that if more information is submitted, that a new plan would need to be developed. So in case it ends up in the hands of the wrong person, there is a backdoor for me as an expert, because if I'm required to do a cost projection, I might not even meet the client. I may just do a phone call or do it from records. And, if I'm going to put 30, 40 hours into a case, I'm going to find out a lot more information, have a much more detailed plan. So I wouldn't want those two plans to kind of not agree with each other. So cost projection is a great tool. I recommend it on settlements. I recommend that you use it for discussion purposes, and that you have a back door so that you can move into a life care plan if needed, if it does progress to trial. So I talked a little bit about what the life care plan and the cost projection is. I'm going to move to the case examples. I think it brings it home a little bit better. So this little guy here in the picture, he was on a bicycle, and he was hit by a motor vehicle. He was paralyzed as a result. He became a paraplegic as a result of this injury, and he was in the hospital. He required extensive rehabilitation, and obviously, because he was 11 years old, there was a huge number of future bills that were expected and a large settlement demand. At the end, it took many years before that reached a settlement because the attorney wanted to make sure that the client had matured and had stabilized, and we know where his plateau was going to be. I've seen that frequently with pediatric cases. But we were called in early on this case, which was actually good. We actually went back several times before they settled the case and updated the plan. But because we were called in early, we were also a resource to the attorney and the family, and were able to make sure that he had state-of-the-art treatment, state-of-the-art equipment, and state-of-the-art providers. What's the advantage of that to an attorney? State-of-the-art providers means that you're getting top-line treaters, you're getting top-line documentation, you're getting, the best of the best, and you're getting information, on what they might need down the line. So in this case, and this was done years ago, but, there were suggestions that because there wasn't complete paralysis, maybe some trace movement in the lower extremities, that this client was a candidate for walking down the line. So we were able to build that in, but also refer him to some specialty programs so that he could get the benefit of treatment in real time and not wait until settlement of the case before he had that treatment. We were able to weigh in regard to home modifications and, give recommendations, vehicle modifications. So there was a double advantage. He had almost a case manager in combination with a life care planner on the case. So this was actually a cost projection. So that was a life care plan, and it was very complicated, involved, was a catastrophic injury. This injury was from a dog bite. So this gentleman was walking his dog, another dog, and came up upon him and his dog and attacked the dog that he was walking. The leashes got tied up with each other, and he fell and broke his hip. It was a homeowner's claim against the owner of the other dog. He had complications. He had some kidney issues, and it slowed down his recovery. So his, wasn't just a standard broken hip. It also made his recovery more complicated because he had some health issues that would, make it harder for him also on a long-term basis to recover. He had some other orthopedic issues. He was an elderly gentleman. So we were able to build that into the cost projection so that the attorney on the case was able to ask for a higher settlement demand to cover his issues. And it was a relatively short report that the attorney was able to use to kind of make his point and then move on to the next case. And obviously, it didn't cost as much as the life care plan. I do suggest that when you're working with serious injury cases, that you work with people who are serious injury experts. Every nurse does not understand spinal cord injury, brain injury, amputations, and complex medical claims. So finding an expert with that background is really important. It's important for credibility, it's important for knowledge, and it's important so that they can build in all of the appropriate things to the life care plan. And even more important, if the case does go to court, being able to support the findings is important. And if the expert doesn't have that background and familiarity with best programs and nationwide centers of excellence, they may not make recommendations that are as defensible. On the opposite side of that, we've been asked to do rebuttals on life care plans or cost projections when somebody has put it together and hasn't had the expertise. It's obvious, and we're able to take a look at that and pull the plan apart, and it's a lot easier to break it down and not be able to defend it without that expertise. Okay, so moving along to case management. Perhaps this is something that you've heard of, but maybe not used so much on your cases. And one of the reasons may be that there's not a direct avenue for payment of the case manager. But I would suggest that you consider the option of using a case manager when you're developing your cases for litigation. It's a powerful tool to find out what's going on with your client, to communicate with the doctor, and to ensure that treatment is implemented. Remember, if you let your client develop the case on their own by going to the doctor without an advocate with them, you may not get things documented in the same way that if you have a knowledgeable medical person attending the appointments with them. I'm sure you've all had clients who go to the doctor and forget to tell them some important things. I have so many examples, but particularly in brain injury cases, where they're not really as aware of their deficits and they certainly can't articulate it. They don't go in and say, you know what, I have a brain injury and I don't remember things and I lose my train of thought in the middle of things and my family says I ramble on and on. Well, if that's not documented, it's going to be hard for you to defend later on. If the client says, well, I did have a knee injury before, they may not be able to explain the before and after to their physician, and the physician doesn't document it. I've had many cases, where they go without somebody to advocate for them, and they don't even tell them that the doctor that they've been in an accident, or they've been in 3 accidents. So you're not going to have the advantage of getting good documentation on your files. You can use a case manager on a 1-shot basis, a 2-shot basis, to go to a very important evaluation, to do a good intake with your client and get a good medical history so you know which documents to get from them. It doesn't have to be, the most costly thing in the world. But if you don't have somebody getting them into good treatment and with good providers, you may not have the best outcomes on your cases. And in situations like this, we've been paid from the third party. We've been paid. I have an example coming up where it was a striker case. So it was a liability case, and the liability carrier had admitted liability, but not settled the case for the final value. So they agreed to pay for the case manager. On a workers' comp situation, you may be able to negotiate to get the case management paid by them. So there may be ways to get the case management services paid for and not rack up a ton of bills on your case. Sometimes having somebody who can just negotiate with insurance carriers and get things paid while you're waiting for your case to settle is a benefit. So just something to consider, and also, helping your client to get proper treatment, improve their quality of life. It's frustrating to see clients who have to sit and wait for 3 years while the litigation develops and not ever really get into any treatment. And at the end of the day, you don't always have the best documentation for your cases either. Another point I would bring up is that a lot of attorneys wait until they send the client to the expert doctor, the expert physician, to develop their case. But if you don't have the early documentation, your expert's not going to be able to give you what you want either. So this is the Stryker case, but this woman had a hip replacement. That's why it says the second hip replacement. So Stryker, I'm sure you've heard of Stryker beds, and the Stryker company also makes hardware for joint replacements. So this woman went in for a joint replacement, and believe it or not, there was a recall of the hardware that Stryker put out, and all of the people who had this hardware put in had to have it taken out and new hardware put in because that hardware was found to be defective. They used a third-party administrator to administrate the claims because they took responsibility for payment of medical bills related to the explantation and the reimplantation of new hardware. But, it's not so simple. For some people, maybe it is. For this woman, it wasn't. She had pre-existing orthopedic problems, multiple problems. She had a joint replacement on the other side. She had back problems. She had neck problems. She had a shoulder problem. She had respiratory issues. She had cancer. She lived alone. She didn't have a lot of support from anybody to really help her. So once the surgery was done, she was debilitated and could not take care of herself back in her home environment. I don't know how many of you have dealt with nursing homes recently, quote-unquote skilled care rehab, but you're lucky if you get a 2-week stay in these programs, and they don't really provide aggressive rehab. So she really was like in no man's land with no place to go. She couldn't go back to her house. She couldn't take care of herself there. So a determination was made for her to go to an assisted living facility. But at the assisted living facility, they also didn't provide the level of services that she needs. So the attorney on the case convinced the third-party administrator to allow for a case manager, and we actually were able to coordinate her care long-term and get her the services that she needed. We were also able to make a case, and this was on the plaintiff's side, obviously, but a lot of her prior issues were exacerbated because of the injuries or because of her debilitation from this surgery. And so she had respiratory complications. I think she ended up back in the hospital about 2 or 3 times after the surgery from complications. And we were able to make sure that the documentation was there to correlate these complications with the surgical intervention that she had so that they were covered as well. Eventually, she did improve. She was a feisty lady and needed some kind of hand-holding and firm limits, I guess I would say, to help her get better. But eventually she did, and she was able to go back home. Another tool that you see under medical legal support is Vocational Services. I would assume that many of you are familiar with vocational services in the standard sense of the word, job development and job placement, future earning capacity, labor market surveys. Those are all tools that a vocational counselor or vocational expert uses. They can be used for therapeutic purposes. They can be used to help move the client along, and they can be used for expert testimony. I'm going to skip to this one, but this is a non-traditional example of a use of a vocational expert. But for those of you who've worked with clients with developmental disabilities or brain injury, it's not a linear recovery that these people make. And so it's not always so obvious, either you can or you can't go back to work, or you have restrictions or you don't have restrictions. A lot of times the work environment is used as a therapeutic modality to develop skills so that the person can return to some type of meaningful activity on a long-term basis. So in this example, a vocational expert was used to help identify volunteer placements that would develop skills in this gentleman so that he could, on a long-term basis, either have a volunteer placement or some type of limited vocational activity that would help him to find some meaning, because he was unable to return to his prior vocational activities, and that's because of brain trauma from an accident. So independent medical evaluation, something that you're all familiar with. I know most attorneys will set them up themselves. And an expert, a medical legal support expert could help you by helping to figure out which specialty to use, perhaps do a file review before the independent medical eval, and develop the letter and questions for the doctor. Remember, if you send the client for an independent medical evaluation and the doctor charges you to review 1,000 pages of records, then he's going to charge you full fare for that. So if you use a medical support expert for this type of thing, it's going to be a lot cheaper for a nurse to do that evaluation than a physician to do that evaluation. And you can target the type of questions that you want him to address in that evaluation. A medical legal support expert can also attend those appointments, and we've done that too for a variety of reasons. Sometimes the reason is to just observe and to be able to give feedback. We've attended appointments where the doctor never even put a finger on the client. We've attended appointments where the client said, but, and the doctor cut them off and wouldn't let them finish their sentence. So the doctor did not know that while the client could move their head to the left or right, that there were certain times of the day when it was just paralyzing, the pain. And the doctor also didn't know that the neck pain prevented them from being able to drive, so that the impact of that neck pain was a whole lot more significant than what the client was, what he was allowing the client to say. We were able to document that in a little mini report that we do after the evaluation, so that the attorney who was handling the file could rebut the independent medical evaluation with something a little bit more substantial than, but it was just an IME. So using somebody to attend those appointments can be helpful at times. A peer review is actually an interesting twist and I don't know how many of you use peer reviews. I find them to be very useful on cases, especially early on a case. So we might do a review of a case, a file review, and we find some pre-existing issues, and we would like to make sure that we can support that the new problems are related to particular incident. We're not sure how that's going to hold up. The attorney doesn't want to send the client out for an IME and get back an IME that helps the other side. So getting the peer review in advance gives us a heads up on whether we'll prevail on the issues that we find on the case. The peer review is non-discoverable. It can be admissible if you choose to do that. It's not as strong as in person, but that's for you to decide on your cases. But a peer review is definitely a tool that can be used, and we frequently will help to set that up on the back end so that we get some opinions on how far we can go with certain issues on the case. So peer review could also include an examination of the bills. Didn't actually talk about the bills, but sometimes looking at the bills gives us an idea of what kind of treatment the client had, what kind of costs were involved, if the costs were inflated, and maybe experts that might be helpful. It doesn't necessarily point it out in the records in black and white, but when you see the bills, there might be examples of some direction that you can go on your case. You can also look at next steps on the case. And I talked about evaluation of relatedness and future needs. So a lot of the focus up until now has been on, personal injury cases. Malpractice cases have their own twists and turns in terms of how you use medical legal support. I think that those are more traditional uses of the services that what I call medical legal services. And I think that it's more intuitive to at least talk to somebody and figure out which tools would be appropriate. Elder care management is something that a medical legal expert may also be able to help with. You may be working with a client who you're setting up a trust. You're working with a family who has a special needs person in the family. I'm going to talk about that in a minute. But you may want to use an expert maybe to get a better outcome just for the family, and they don't know where to turn in terms of care, in terms of how to use trust monies that are put aside. Can they stay at home? Would an assisted living facility be more appropriate? How do I navigate through the long-term care insurance to get the most bang for their buck on that? What kind of equipment would be appropriate? They have caregivers, but are the caregivers appropriate? Making sure that they're safe and independent. So we had an elder care case I can tell you about. We had two brothers. Neither of them were guardians of the elderly mother. The one brother, I'll call him the bad brother, was living with Mom, and Mom was supporting him with whatever money she did have, and he wasn't providing what the other brother thought was adequate care. He wanted to secure guardianship so that he could move his mom into an assisted living facility or a nursing home. He wasn't sure which was appropriate, but he had to at first he had to show that his brother wasn't providing competent care. So he hired an elder care case manager to go in and do an evaluation to see if she was safe in the home. Well, in that evaluation, the case manager saw that, number one, the brother was not taking adequate care of his mom. He had women in there taking care of her who were not certified, had no qualifications, were giving her medication, and were giving it improperly. She never, hardly ever got out of the bed. We could see no evidence of her getting out of her bed. And if she had to get out of the house, they couldn't take her out of the house because there were steps. There was only one entrance in and out of the house, which would essentially make it a hazard, a fire hazard, if she needed to get out. And when we went into the house to see her, we saw about 1,000 cigarette butts on the wooden porch in front of the house. So the brother was sitting on the porch, I guess, a significant amount of the day smoking cigarettes, but that also posed a fire hazard for the mother. So once we were able to write up that report, the attorney on the file gathered some additional evidence and was able to help the other brother apply for guardianship, get the mother moved out of the home, and use her remaining resources for the mom and not for the other brother who was apparently just living off of his mother's resources. I talk about guardianship support. So I think guardianship support, by that I mean normally people who have special needs individuals in their family, and we've been seeing more and more of this. Parents who have kept their developmentally challenged child and have done a really good job in terms of keeping them engaged and occupied and cared for, but they've never entered the system, and so they don't have benefits, and the parents get elderly and can't take care of them. On the other side of things, we see special needs families where the parents are trying to put aside a trust and figure out how to put aside the proper amount and figure out what that family member is going to need for the rest of their life. And in those cases, they've retained the services of a medical legal support expert to help them along that journey. We had one case where a guardian contacted us, a special needs child with a special needs trust. Mom was the guardian, and they never established another guardian. And the child, it was a birth injury, so anoxic at birth with cerebral palsy, and the child she never really engaged him in proper services. He didn't have a good physiatrist, and she was just taking care of him to the best of her ability, but she was living in a 3-story house. He was a little guy, and she was carrying him up and down the steps, in and out of the car. But he was about to get much bigger, and that would not be appropriate. So Mom came to the trust and asked for money for a new house, and the trust fund manager engaged our services to, see if that was the most appropriate thing. Well, we were able to sort of back it up a whole bunch of notches and look at the kind of therapy and treatment the child needed. We were able to get him into a school through the school program, so a private school where the school had to pay for it, get him good therapy services, get better equipment for him so that Mom wouldn't have to carry him up and down the steps, could get a van with the money that was in the trust, and eventually worked on the house. But that was kind of the last of the issues because he wasn't getting proper care. And this will impact his quality of life down the line, too. So basically making sure that the monies that were in the trust were spent wisely and where there were public monies, that he was taking advantage of that, and where there were private money, we use that to the best advantage too. So now Q&A. Any questions?
Thanks. If all the attendees can enter in the passcode, which is support, and any questions that you have. Our first question, you mentioned evaluating billing issues. Do you also have experience with or able to align regarding medical billing issue as it pertains to miscoding?
Yes, we can. I do have one coding expert that we work with, and she's able to not only look at the codes, but she's testified to when coding is incorrect. So there's two ways, there's two parts to the answer to that question. The first part is as a generic, does it look right, and should I be fighting it? And then second, should I attack it, and is this, do I need an expert to support it? And I guess figuring out first which side you need, and then we can match you up with the expert if it needs to be taken to the next level.
Okay. That was the only question. If you could just finish up with the presentation, just if you had any last-minute words.
I think, I guess in summary, what I would say, I covered a lot of ground. I do it as a more generic kind of an overview to give attorneys an idea of kind of how to use somebody with medical expertise to help you get better outcomes on your cases. I would say that each of the categories that I went into could be a presentation in and of itself. So, if there are particular areas that seemed interesting but superficial and you would like to hear more about that in the future, I would love to have that feedback. If a particular issue was helpful, then I would also love to have that feedback so we can make that a heavier focus in future presentations. Overall, I would say that partnering with somebody with medical legal expertise can really give you a new view, a new vision of how to work the file. And when there's, I guess the most important thing that I would emphasize is dialogue. When there's no dialogue, you can't get good results. When there's dialogue about what you want, what you need, don't be afraid to tell your expert that, there's a policy limit, that it's a low dollar case and you're looking for something that's, just to get you to X, or, this is going to be a long-term case and we're going to take it in stages, or to say, I'm going to give you some records. I want you to come back to me with some suggestions before we take a deep dive into this. So, the more dialogue there is, the better job that your person can do, and also the better we can match up the expertise with the person, the type of case that you're looking for, that you're looking at.
We actually just got some few more questions.
Okay.
The next question, do you have a resource list for case managers?
We do, yes. We have a whole team of case managers, not just throughout the country.
Next question. How are the experts paid in various categories you presented, upfront payments or out of settlements?
Say that last part?
Sure. Are they paid upfront payments or out of settlements?
So each... Or what?
No, I was just repeating the question again.
Oh, okay. So I think you said upfront payment or out of the settlement. So, that's negotiable on each case. So it could be either one. Sometimes we'll take a retainer and work off of the retainer. Sometimes it's paid out of the settlement. So I think that just depends on the discussion up front.
Next question. Can you give some monetary ranges of the cost for a life care plan versus a projection cost?
That's a great question. So depending, a lot of it depends on the number of records and how in depth you want to go. But the guy that I just did one pretty simple one, it was in the $2,000 to $3,000 range. That was a cost projection. And you have to be able to, it does take time to go through the facts to get enough information to cost it out. So I would say that that's a range. A more complicated one might go up to 5, but that would be one with a lot of records and where we're talking to the client as well. A life care plan, I've seen them from $5,000 to $50,000. I have never, ever done one at that range. So I would tell you that you want to talk to your life care planner up front to establish a budget. It's not unreasonable for a life care plan to be in the $7,500 to $12,500 range, especially if it's a catastrophic, something catastrophic. A pediatric case could be more. So I would say that you want to discuss that up front. But life care planners, there's a huge variation in what they charge. And I've recently conferred with some competitors, and I was just totally floored by what some of them. And I guess to maybe a different way of answering that question is your expert really needs to take into consideration what your budget is and what you're trying to accomplish on the case. It's just not worth it to do a $15,000 life care plan when you have a $100,000 policy limit. As pretty as the plan could be, that's not what you want. So from my perspective, I feel that it's irresponsible to not have that conversation up front and to not make recommendations for using a product that would coincide with the results you're trying to get. And there may be other ways to skin the cat and to get what you need without doing the 50-page plan.
And the last question is just a follow-up regarding the resource list. They just wanted to know where they can locate the list of case managers.
They would call Advanced Rehab Management, and I don't have a list online. They would have to call Advanced Rehab Management, which is the our number is on our information, or they can go through TASA, and we would assign a case manager based on the geographic location and the what the needs of the case are.
Thank you. Please remember that if you are applying for credit, you must attend it for the full 60 minutes of this presentation. You're also required to complete the survey at the end of the program. Just a reminder that you will be receiving your certificates via email in 24 to 48 hours after this presentation. I want to take this opportunity to thank everyone for attending, and most especially Deborah Weiner Katz for her time and effort in creating this presentation. If you would like to speak with Debbi, or if you would like to speak with a TASA representative regarding an expert witness, please contact TASA at 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's presentation. Again, thank you all for attending today. This concludes our program.